go. What's up, everybody? All right. What's up, everybody? Oh, let's see. So let's see. Mic check, mic check. Should be able to sound pretty good there. What's up, everybody? Make sure all my audios are down. There we go. There is no echo, no reverb. Now, let's see. I think I want to get in a little bit of trouble tonight. We'll see. I'm going to read some notes. Got some books here. Let's put that over there. What's up, everybody? What's up? What's up? Then we're gonna, no, we can leave that there for now. But I think I want to read some stuff, make sure I got a good grasp on explaining it. See if anybody else comes on. If they let me show my stuff to more people. They said we're not showing this stuff to nobody, little bro. You can go ahead and cut it out. Let's see. We're gonna talk about jurisdiction. Statutes. Let's see. Let me see if anybody else comes up. Let me pull up some stuff. All right, let's What's up, everybody? What's up? What states are we from? What states are we from? Let's see here. We're going to talk about jurisdiction. Let's do that. Jurisdiction. Then we're going to do we're going to talk about codes. So actually, that's right. This is wrong. Let's search the word code. Okay, let's do this. What's up, everybody? What's up? What's up? I think I'll start with this. Code. Washington says code is not the law. 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 Code is not law. Georgia code. What is it I wanted to talk about? Let me see what jurisdiction has. Texas. Code is not the law. Georgia code. Constitution. Jurisdiction. All right. What is jurisdiction? Territorial jurisdiction. Long arm statutes. Let's do that. All right. I'm going to read some stuff. That's not what I want. Federal. What's up, everybody? What's up? Federal. Yes. Beautiful. What's up, everybody? We're about to get this party started. We're ready. If anybody wondering, this is my special apple juice. Okay, great. As always, we're going to start with the United States Constitution. Let me see here. Beautiful. All right. We're going to go to the Constitution. And we're going to go to, we did it already today, Article 1, Section Section 8. Article 1, Section 8. Article 1, Section 8. Article 1, Section 8. Article 1, Section 8 says that Congress shall have the power to exercise exclusive legislation in all cases whatsoever, comma, over such district. Parentheses, not exceeding 10 miles square. And they said if they do exceed the 10 miles square, it is by the consent of the legislator of the state. And the purpose that they would be exceeding the 10-mile square for is with the consent of the legislator of the state for the erection of federal forts, federal magazines, arsenals, dockyards, and other needful buildings. That's what the Constitution says, right? Nobody should have a problem with this. Let's see here. Where was I going to start? Let's do the hierarchy of federal law. So, what is the hierarchy of federal law? The hierarchy of federal law is as follows. Obviously, federal law pertains to federal things. Federal law pertains to federal things. Say that. Federal law pertains to federal things. So you have the United States Constitution. What does the United States Constitution do? The United States Constitution creates three departments of government. It creates a federal legislative branch. It creates a federal executive branch, and then it creates a federal judiciary branch. So, what is the purpose of the federal constitution? To create three branches of government for federal government. Remember, 1776, there were 13 state governments that already existed. And the Supreme Court said on multiple occasions when the federal constitution came out, this constitution did not change those state governments. They said they were accepted as precisely as they were. So you have the federal constitution, which create three branches of government pertaining to federal things. You have Congress, you have the executive, you have the judiciary. Then after that, Congress has permission from the Constitution to enact statutes and legislative enactments based on the operation of the Constitution for the operation of this federal government or this federal corporation, whatever you want to call it. And as a result, that's what they do. They write statutes, codes, regulations, ordinances. That's what they do all day, every day. Then you got the executive branch. They execute those statutes. And then the judiciary, they make explanations or they enforce those that are bound by those statutes. Then you have the United States statutes at large. What is the United States statutes at large? The United States statutes at large is the official legislation of Congress. So if I ask you, what is federal law? There is no other answer than the United States statutes at large. Somebody say that. The United States statutes at large. You can say SAL, USSAL. So technically, that's it. When they say federal law, they mean something that has been logically and lawfully enacted by Congress for the operation of the government. Technically, it's just the Constitution, and then it's the United States statutes at large. Technically, that's it. If I ask you what's federal law, you just have to say the United States statutes at large. Technically, that's it. And I'm going to prove that to you in a second. The United States statutes at large, you can Google this. I'm not telling you something that's some conspiracy theory. This is the law. The United States statutes at large is the official legislation of Congress. If it's not in the United States statutes at large, it is not law. It is not federal law. All right. So the United States statutes at large is enacted by Congress. They have sessions, they argue, debate, vote, make statutes. That's what they do all day, every day. Right. After that, after they've created a statute, then they have this thing called the Law of Revision Council that takes those statutes and categorizes them into the United States Code. So you have the Constitution, you have the United States statutes at large, then you have the United States Code. The United States Code takes those statutes from the United States statutes at large, and then they categorize them or put them into bite-sized pieces into different, what they call titles or subject matter related to the operation of the government. So if it has to do with the military, then they'll put that statute and codify it in the military title. If it has to do with banking, then they're going to put it in the banking category. If it has to do with federal crimes, then they're going to put it in the federal crimes in criminal justice statute. If it has to do with nationality or immigration, then they will assign those statutes and put them in the correct category. And then they will codify it, and then they will publish that as the United States Code. So right now, I have it. I think there's 54 titles or what they call subject matter. So 54 subjects related to the operation of the federal corporation, federal government. Man, you can't even go to the United States Code website. There we go. Yeah, they got 54. So they got what? They got Congress, they got the president, they got the flag, the seal, the seat of government, and the states, in which no state is mentioned. They got the government, they got domestic security. Domestic to who? Domestic to the District of Columbia. They said agriculture, aliens and nationality, arbitration, armed forces, bankruptcy, banks and banking, census, Coast Guard, commerce, conservation, copyrights, crimes and criminal procedures, customs duties, education, food and drugs, foreign relations and intercourse, which is also commerce, highways, hospitals, Indians, the Internal Revenue Code, intoxicating liquors, the judiciary and judicial procedure, labor. What kind of labor? Federal labor. Let's see if I can move that. I can't see. Then you got mineral lands and mining. You have money and finance. You have the National Guard. You have navigation and navigable waters. You have crime control and law enforcement, patents, patriotic, and yada, 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 veterans pay, public buildings. All of these different topics related to the operation of the government. You got railroads, public lands, public printing and documents, shipping, telecommunications, territories and insular possessions, transportation, war, national defense, voting, national parks, and service. Now, notice out of those 54 titles, they don't have one called citizenship. I digress. Anyway, so you have the United States Constitution, you have the United States statutes at large, then you have the United States Code. After they have codified a statute, then they create regulations to implement that code or that statute. So then you would have the Code of Federal Regulations. So you have the United States Constitution, you have the United States statutes at large, then you have the United States Code, then you have the Code of Federal Regulations. That is the hierarchy of federal law. Then I'm gonna see where else I want to go with that. All right, so let me prove this to you real quick. The code is not law. Okay, I told you earlier, the United States Constitution and the United States statutes at large is federal law. People say all the time, oh, federal law trumps state law. You don't know what federal law is. You don't know what state law is. Federal law is just the United States statutes at large. If it's not in the United States statutes at large and it's not talking to you from the United States statutes at large, the Supreme Court of New York taught us if we're not named in the statute, it does not apply to us. So if they don't mention Alabama, Alaska, Arizona in the United States statutes at large as telling them what they can and can't do, well, guess what? They're not talking to Alabama, Alaska, Arizona, Arkansas. What court case was that? Uh, I don't. I don't think I read a court case yet. I don't know what I just said. So, I know that sounds hilarious, but um, I forgot what I was talking about. We were talking about statutes. Oh, the United States statutes at large. The United States statutes at large. If it's not in the United States statutes at large, what did I say? I did cite something, didn't I? I said, what did I say? It was good, wasn't it? I forgot what I said, but I was saying if they didn't put it in the United States statutes at large, if it's not talking to or from the United States statutes at large, it's not talking to Alabama, Alaska, Arizona, Arkansas, right? All right. Now, what I was talking about is that the United States Code is not law. No code in America is the law. That's the point that I was trying to make. Uh, so you won't find a statute or a code or a regulation that is from the federal. We're talking about federal law here. That is coming from Congress talking to or telling a state what they can and can't do. That's essentially what I was saying. So, for example, to qualify these statements, we go to the state Supreme Courts, right? So, my argument is that the code is not the law. So, they said a code is not within the letter or spirit of the mandate of the Constitution. What do you mean? That's all they cite is the United States Code or a state code and they put people in jail over these codes. The Supreme Court of Alabama said that a code is not within the letter or the spirit of the mandate of the Constitution. They're talking about the Alabama Constitution. They said, nor can it be supposed that it was within the contemplation of the framers of the Constitution. They said, no, this is state. So they said a code is not within the letter or the spirit of the mandate of the United States Constitution. They said, nor can it be supposed that it was in contemplation of the framers of the code. They said when they created the federal or state constitutions, they said what they knew what it was. I'm being facetious, but they're like, well, what is a code? We don't do codes here. We have law. And law is largely in this country invisible. If you're on the Patreon, just search Alabama or just search the word code. And they said, oh, so yeah, they said a code is not within the letter or spirit of the Constitution. They said that's not the law. They said Alabama has a law. What's the law of Alabama? Right? So they said, this is Georgia. The Supreme Court of Georgia said, a code or system of law enacted by a single act of the General Assembly, they're talking about Georgia, is not within, again, here's that letter, here's that phrase, letter or spirit of the mandate of the Georgia Constitution. They said a code or system of law or enacted by a single act of the legislator is not within the letter or spirit of the mandate of the Constitution. So if I ask you, is the code law? It is not. The answer is no. All right. So the Supreme Court Georgia said in another case that this court, what court? The Supreme Court of Georgia said that this thing called the annotated code is not the law. What do you mean it's not the law? That's all they do. They put people in jail over the law, right? That's what they do. They law enforcement. They said this thing called the annotated code, for those who live in Georgia, they call it, what do they call it? The oh, what do they call it? It's like two C's. They call it the general something code, the annotated code of Georgia, something like that. I think that's what it's called. The annotated code of Georgia is not the law. They said this court, what court? The Supreme Court of Georgia said, oh yeah, that's not the law. What you mean it's not the law? That's all they talk about. They say, they get on the news every day, say, oh, they got a new law. Oh, they came out with a new law. Oh, we got a new law, everybody. They said there has been, this is another case. The Supreme Court of Georgia said there has been no legislative enactment officially adopting such code as law. What do you mean? That's all they do. That's there they go. They call it the Georgia Code Annotated. The Georgia Code Annotated is there to locate the law. They said the Georgia Code Annotated is not a legal citation. And they said we cannot take judicial notice of it. They said, what do you mean? You can't take judicial. This is, I thought we were here about the law. They said, yeah, that's not the law. So we only deal with, the Supreme Court of Georgia only deals with constitutional questions. They only deal with stuff related to the law. So you bring the issue of the code up to them and they say, I don't know what that is. They said, we don't know nothing about no code. They said we were created by the Constitution. And so our only job is to measure what comes before us against the Constitution. Why? Because the Constitution of Georgia is the law of Georgia, which we know as it pertains to the government. The law of Georgia is the common law of England. The law of the people is the common law of England. So they said this constitutional question, which only got to us by way of a statute, which only got to us by way of a fiction, which only got to us by way of commerce. They said, even in commerce, as we look at this corporate charter called the Georgia Constitution, this thing called the code, oh, we can't take judicial. That's not a legal citation. That's literally what they said. That's not a citation. We don't have no books called the Georgia Code. That's not Georgia law. They said it alone does not constitute a legal citation, and the Georgia Supreme Court cannot take judicial notice of it. The Supreme Court of Georgia said the object of codification was not to make laws. They said, where'd y'all get this idea? I'm being facetious again. But they said, that's not the law. They said it cannot be doubted that the code is the law. They said this code can't even change the law. What years was that? It was after the Georgia Constitution. It was in the 1900s, all of those cases. Well, except for one of them was it was after the Civil War. They're all after the Civil War. All right, so now we get to the federal. They said the official source, so this is the federal question now. So they said, okay, this is the Federal Circuit Court. They said the official source to find what they call United States laws, which is a statement in the United States Constitution, is in the United States statutes at large. They said this thing called the United States Code is not United States laws. They said unless, this is another case. They said unless, this is another circuit court case. They said unless Congress enacts the code into law. I thought the code was the law. I'm being hypothetical. They said no, the code's not the law. They said that code would have to be put into law, which technically is not lawful because it would have to come from the top down. The statutes at large would be lawful, and then you would have to put what is in the statutes and then codify it. They're just telling you, they're putting stuff into the code that's not law. They said that title is only that title of the United States Code is only prima facie evidence. That means it only at first appearance. They said the very meaning is that this thing called the code, it doesn't have any weight over the United States statutes at large as it pertains to federal things. Here's another case. This is the Supreme Court. They said this thing called the United States Code is immaterial. What do you mean it's immaterial? They said this stuff can't be admitted into court. What are you talking about? What do you mean question us about the United States Code? We don't know nothing about no United States Code. That's what they're lying to our face. But they're saying well, the United States Code is immaterial. They said this stuff can't be admitted into court. This is not material evidence that we can. What did Georgia say? It's not a legal citation. We can't take judicial notice of it. They said somebody else did this that wasn't authorized by law. They said, again, they said the United States Code cannot prevail over the statutes at large. Here's another case. Another case says that, well, much of this defendant's argument rests on the language that has been quoted from the United States Code. And they said, rather than from the law. How many scammers and people on the internet, all they cite is the United States Code. They got little screenshots while they try to explain to you the United States Code. These courts, they said, we don't do the United States Code. They said that's not the law. They said this dude's in court trying to argue his civil rights that come from the United States Code. What they say, the 1983. They say we're gonna sue them based on, people tell me all the time, the 1983 code. I don't even know what code that is, but the 1983 code. They said they said much of this defendant's argument rests on the language that has been quoted from the United States Code rather than from the law. They said this stuff is not. All these scammers you see on the internet talking about, the United States Code. You gotta, this is the law. That's the law. That's not when you get in court, it ain't. Yeah, beware. Beware. The Bible says, be wary of itching ears and the doctrine of demons. They said this thing called the United States Code is not law. Just like Georgia said, this thing called the code, we cannot, the Supreme Court said I don't see that in our books here. You see that? Yeah, they don't have no such thing as the code in the common law of England. I'm so sorry, everybody. They said this stuff is not the law. They said the United States statutes at large is legal evidence of laws in federal court. You get to the Supreme Court of Washington State on the West Coast. They say, this thing called the Revised Code of Washington is not the law. What do you mean it's not the law? That's all they do. They give you a ticket. They got the whatever state code on there that you supposedly violated, which we talked about earlier today. A statute and a code can't be violated. They said, yeah, I don't know where you're getting this from. They act like they never heard it. I'll tell you, these people looking dead in your face, and if it ain't if they can't take judicial notice of it, they say, we don't. What are you talking about? So they lie. They get backed into a corner because they say they don't do admiralty, which all they do is admiralty. Then they say they don't do the common law no more. But every case you read say is always the common law principle. And then when it's a liability that can occur on them, they say, oh no, we don't no Washington code here, no United States code here. No, you've been enforcing this stuff based on codes. Right? So they say, the Washington code is not the law. What do you mean it's not the law? There's people in prison right now, in jail, in prisons right now over a code. See, they need to start calling it law enforcement. They need to call it what? Code enforcement. Somebody type it in the comments. Code is not law. Code is not the law. Code is not the law. They said this stuff is not the law. I don't know where you're getting this stuff from. We never heard of it. What are you drinking? Oh, this is apple juice, everybody. Very, very incredible apple juice. Sorry, YouTube. I can't even find the chat. So yeah, they say it twice. I got two cases. They say, well, the Supreme Court of Washington State said, oh yeah, the code of Washington is not the law. I'm so sorry. Because people go in there trying to argue United States codes and all this stuff. They said that's not the law. I don't know who's telling you that. No, the scammer on the internet told me it was the law. I didn't hear it ain't. Right? And so I kind of forgot where I was going with that, but we're going over the hierarchy of federal law. So when we talk about federal law, technically, obviously, you have the United States Constitution, which creates government. That's what it does. It creates government and it tells the government what it can and can't do. Right? Simple enough. Then you get to United States statutes at large. The United States statutes at large can only create things. We read it earlier today for those who were on. Okay, well, they can't just be creating things and creating presumptions, irrebuttable presumptions, and writing so-called statutes that can impair rights. No, I don't chat about my findings. If you want proof or evidence of what I'm talking about, you can join the Patreon. This stuff is not up for debate, and the real judges who make decisions on the law are called the jury. So we don't debate or chat about what I found. I present evidence to the jury and they make decisions. And if you haven't consented to this stuff, none of this stuff would apply to you in the first place. All right. So again, the code is not the law. Somebody said, nobody said it yet. The code is not the law. The code is not the law. Where was I going with that? It was really good. I forgot. We were talking about jurisdiction. Let's see. Only. I think I know where I was headed. Only. Let's see. Only applies. I need that. Finna read that. There we go. Need that. Oh, I already read that. Only. Oh, beautiful. Okay, so this is how we qualify those statements. Bet, right? So we just read the code is not the law, right? The code is not the law. The code is not the law. Why? Because a code is not law. They said they can't give a legal citation of it. They can't take judicial notice of it. They said it is not within the spirit of the letter of the Constitution of your state. And then when you get on the federal side, they said, well, the United States Code is not the law because we're a corporation called the United States and we only have authority over district things. Then the United States statutes at large is only federal law, right? If it applies all over the union, then you have to apply common law due process before you try to enforce it against anybody. And it still can't be presumed or suggested or written to impair or deprive or take away rights, right? Because the purpose of government is to secure rights. That's the purpose of our government. I don't know how they do it in Africa and all the countries there or in Australia, but here in the 50 states, the purpose of government is to secure rights. So they've never been given permission to write things that can take them away. All right. And it's not supposed to be presumed that they have the power to do so because they don't have the power to do so. They've never been given it and they can't prove they have the power to do so. All right. Now let's get in trouble. Y'all ready? Only. Here we go. They said the legislation of Congress. Now, let me, because you don't have to believe me, but we got to start with the Constitution, right? It was the supreme law of the land. Okay, let's go to the Constitution. Article 1, Section 8 says that Congress shall have the power to exercise exclusive legislation in all cases whatsoever over such district. And then they got a little thing called the parentheses. And in the parentheses, they say we don't exceed the 10-mile square, right? And then they said, if we're going to exceed the 10-mile square, then we have to have the consent of the legislator of the state. And if we get the consent of the legislator of the state, then the purpose of us exceeding the 10-mile square would be for federal things. And they say them: the erection of forts, magazines, arsenals, dockyards, other needful buildings, right? They said we call these things the United States. Does that make sense? They said we don't call these things Virginia. We don't call these things Kentucky. We don't call these things Oklahoma. We don't call these things Colorado. They said we call this the United States. So the United States Supreme Court said the legislation of Congress applies only within the territorial jurisdiction of the United States. Remember, we went to the United States Code and we couldn't find one state mentioned in the United States Code. They got a whole title in the United States Code called states, and not one state is mentioned. How we use this in court, bro. You don't use this in court. You're supposed to know the law to keep from being in court. You only end up in there. There's two courts, right? You have federal court, which is a different fight, and then you have state courts. You only get in court by way of a legal fiction. If you have a driver's license, if you have a state ID, if you drive a car that is on their computer, that is how they have the ability to create a case on you. So my job is to teach the law so you don't end up in court. See, there we go. That's not our reality. See, we can't speak for everybody in generalizations. That's what the government does, and that's how they get in trouble. We're dealing with fines and foreclosures. How do they have the ability to create fines and foreclosures? How do they know who you are? How did they know who to give the fine to? Because the Fifth Amendment, we love talking about the Fifth Amendment. The Fifth Amendment says you have the power not to be compelled to be a witness against yourself. So how did they know who you were? He said, we're already in the thick of it. Okay, well, who are the judges of the law? Okay, but let's define the judges. Who are the judges? Who did you present this information to? Because when I ask everybody every day that I get on a live, what is your state? And then I prove to you that the law of your state is the common law of England based on the Supreme Court decisions of your state. That gives you an incredible homework assignment to start learning the common law of England. So, again, the legislation of Congress only applies within the territorial jurisdiction of the United States. They said the legislation of Congress applies only within the territorial jurisdiction of the United States. They said again in another case, this is all Supreme Court, the legislation of Congress applies only where? The territorial jurisdiction of the United States. They said this is a long-standing principle of American law that legislation of Congress apply only within the territorial jurisdiction of the United States. We just read it. Where does, based on the United States Constitution, does federal legislation apply over such district? So when someone is foreclosed on, what do we do to defend our homes? If it had the ability to be foreclosed on, it probably wasn't our home. This is like people say all the time, well, my car, it's my car. I purchased it. Well, what's the proof of ownership of a car purchase? The proof of ownership of a car purchase is the manufacturer certificate of origin. And if you did not get that at the time of purchase of a car without a loan, then you do not own that car. And if it had the ability to show up on the cop's computer, then that's not your car. Because people who own their cars, people who have this magical, mythical right to travel, don't end up on the cop's computer. Right? So, again, what's the proof that you owned the home? Because getting a loan from a bank is not proof of ownership. The only proof that you owned it would be commercially that the courts could take judicial recognition of, that you could actually put up a fight with, is a land patent or a land grant from a foreign government. Because I just read it. The legislation of Congress only applies within the territorial jurisdiction of the United States. Since the Civil War, we've had no state governments. They've all been federal. So anything you thought you were doing with the state, we've had no state since 1865. It's just us. So they said when we give out land grants or we give out land patents, it takes that property, that land, out of the public domain. And when it's out the public domain, it doesn't have the ability to be foreclosed on. Why? Because these so-called state ofs who are acting within or in this state or within this state is on the exterior. boundaries of the state. So they have been ceded to the United States Federal Corporation. So how does a commercial bank, which is only under the exclusive legislation of Congress, have the ability to attach and create a lien or create a court case against it? The same way we showed up at the DMV and asked for a state ID because we gave them the information. How did they know your house exists? How did they know your piece of land exists? He said the legislation of Congress only applies in the territorial district. They said it only applies over Social Security Administration offices, the post office, the FBI office, the military base. It only applies over their territory. They said it's a longstanding principle of American law that the legislation of Congress apply only within the territorial jurisdiction of the United States. It says it rests on the principle or the perception, my bad, that Congress ordinarily legislates with respect to domestic, not foreign matters. Domestic to who? Domestic to the District of Columbia. They said, we're not talking to Virginia. We're not talking to Kentucky. They said, we're not talking to California. We're not talking to Wisconsin. They said, we talking to ourselves. And if you're not minding your business and you paying attention to us and you believe we're talking to you, oh, well, then we in trouble. This is why I tell us we have to focus on our states. We don't know the history of our states. When I say the states are sovereign, people look at me like, oh, yeah, that sounds real cool. And then I ask you, okay, well, what was the charter that went from, because the feds didn't exist in 1776. So where'd it go? Who'd they get the land from? Who did Georgia, Virginia, Massachusetts, who'd they get the land from? What's the evidence? What's the proof that it's Georgia's and not England's or Britain? Okay, well, they gave that land to Pennsylvania in 1783. In the Treaty of Paris, they say it, the King George III acknowledges the sovereignty of the 13 states. And he said he gave them all the land. Okay, well, what's the proof of that? Okay, it's time to do some homework. Where did Texas come from? Who had Texas before? Who had Texas before Texas was independent? Because Texas was independent. But before then, they were under Spain or Mexico or whatever. I don't know. I'm not from Texas. But that's your homework assignment. This is more than just play. You got to know this stuff. You got to be able to prove all this stuff to a jury to say, hey, this fictitious corporation has never had authority over my land. Why? Because they only have authority over such district. I wrote the Land Bureau and said, hey, can you say that where I work and where I stay has been ceded to Congress in the District of Columbia? They said, you write them back. They said, no, we haven't given that piece of land. We haven't given these coordinates. We haven't given these metes of bounds to the District of Columbia. They said where you live is under the exclusive lawful common law de jure legislation of Kentucky. I just keep using Kentucky as an example. Under Tennessee, under North Carolina. They said we never gave this stuff to them. Okay, bet. So when I scrutinize the code and the statutes and I say, and I see that it's all based on federal things, okay, well, when I present that to the lawful judges, then I'll know I got the job done. So they said the canon of construction teaches that unless a contrary intent appears, federal statutes apply only within the territorial district of the United States. All right, now here we go. This is the United States Supreme Court. They said special provision is made in the Constitution for the cession of jurisdiction from states over places where the federal government shall establish forts and other military works. And they said it is in only these places where it can exercise jurisdiction. Look, they cite Louisiana. They said Louisiana was admitted into the union on the same footing as the original states. Well, what happened to the original state? The original states were never federal territory. So when you join that union that existed before there was such thing as a federal corporation, okay, well, you get attached to that sovereignty. That's why I told y'all yesterday about Texas and California. They were never federal territory. So when you look at their laws, they don't hide nothing. They tell you everything. They say, yeah, the feds, they say in Texas, the feds only lease the land. They've never purchased land in Texas. They say all the military, everything they operating out of is based on a lease, which this is true all over the country, but it's easier displayed in Texas and California. They said that California said, oh yeah, the Supreme Court or California and the United States are two separate sovereignties. They said they do their thing, we do our thing. As long as we're not violating the federal constitution, which 9 times out of 10, they're not, then they don't talk to us. We don't need to talk to them. Now, I'm just speaking in hypotheticals, right? We know they disregard the law. I'm just saying that these lands are still American Indian land. Well, where they at? Everybody say, oh, this they land, but I don't see none of them. See, we don't like the fact that in the Bible, they tell the people of God to take over lands. We don't like that because you've never had to defend anything and you don't know what incredible work it takes to do that. Also, it's still American Indian lands, yada, yada, yada. Yeah, that sounds great. So they said Louisiana was admitted into the union on the same footing with the original states. Her rights of sovereignty are the same by consequence. They said there is no federal jurisdiction. There is no jurisdiction of the federal government, police or otherwise, that can be exercised on this public ground. What public ground? Louisiana. They said all powers which appertain to sovereignty belong to the states, not to Indians. They said belong to the states or to the people, and to the people. Here we go. United States Supreme. Nope, this is the New York Supreme Court. Who is this? Is this Thurgood Marshall? This is Chief Justice Marshall. He said that the right of exclusive legislation within the territorial limits of any state can be acquired only by consent of the legislator of the state, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. They said for one of the specific area enumerated objects. No. They said the states can freely cede these lands for one of the specific enumerated objects. So they said what we said it all night tonight: forts, magazines, arsenals, dockyards, other needful buildings. They said the states can freely give those things up. They said jurisdiction cannot be acquired tortiously or by the disseeing of the state, much less can it be acquired by mere occupancy. They said to oust this state of its jurisdiction to punish crimes, it must be shown that an offense committed within the acknowledged limit of the states. And to bring the offense within the jurisdiction of the courts of the union, it must have been committed out of any jurisdiction of the state. All right, let's see here. He said he gave me a chance. I don't work for him. These people be hilarious. I don't owe you anything. You'd pay nothing to watch this. They said the purpose of the statutes is to implement. I said this. The purpose of the statutes is to implement the powers delegated to Congress by the Constitution. They said there are two types of statutes: United States statutes at large, the United States Code. We're talking about federal things. They said titles which are not enacted into positive law are called prima facie evidence of laws, presumed. They said due process of law does not allow for a presumption. Title 26 of the United States Code has not been enacted into positive law, and as a result, it is a presumption. It was a presumption by way of it being in the code, but it's definitely a presumption because it was not enacted into positive law. Does that make sense? So again, titles which are not enacted into positive law are prima facie evidence of laws. If it wasn't enacted into positive law, what does that mean? Lawfully, according to the Constitution, which can't be interpreted without the common law of England, which is due process and a trial by jury, then it is prima facie evidence. It means at first glance. It means if you look at it and they call it law, sure, you might believe it's law, but don't scrutinize it. You might not end up at law. You might end up at presumption. Does that make sense? And due process of law does not allow for a presumption. You have to be able to prove, not you, them have to be able to prove that this was lawfully authorized by Congress, and it can't be presumed to take away rights given under the Constitution. Now, regulations. Regulations are what they call rules. Regulations have implementing or administering statutes. So see it like this, right? You have the United States Constitution. The United States Constitution creates a skeleton. And the regulation puts meat on those bones. Does that make sense? So you can't have one without the other in order for it to be a complete body of law. So if you have statutes and you don't have implementing regulations on how to execute the statute, you can't call it law authorized by the Constitution. I feel like I'm talking over your head. Statutes are the skeleton. Regulations put meat on the skeleton. The United States statutes at large is federal law. How do they implement federal law? Through the regulations. Because remember, the United States Code is not law. So they said they assign a specific agency to take responsibility for investigating and enforcing specific statutes. They inform the public on how they are interpreted, and the statutes applied to them are to be published in the Federal Register. Somebody say Federal Register. So you have the United States statutes at large. You have the Code of Federal Regulations. The statute is the law. How they implement the law is through regulations. That means how they enforce it, right? Now, here's the kicker. If they don't put the regulation of the statute that they're trying to enforce into the Federal Register, it is not enforceable. So I'm going to say it a bunch of times so you get it. You have the statute, you have the regulation on how to implement or enforce the statute. If that regulation has not been published in the Federal Register, it is void and unenforceable. Say Federal Register. That should be a cuss word. They said we're not going to say it. All right. Congress enacts a law into the United States statutes at large. The Law of Revision Council of the House of Representatives will write or implement the statute into the United States Code by dividing it up into title or subject matter. So they expand the United States Code based on the enactments of Congress. Like, I don't know. I haven't always looked at the code, but the United States Code used to be 50 titles and now it's 54 titles, right? Because as Congress expands things, then they codify it and put it into a title of the United States Code, right? Where's that? So the Law of Revision Council of the House of Representatives, which I might add has not been authorized by any law. That's why the United States Code is not law, because these people that create the United States Code have not been are not delegated authority from the Constitution. That's another argument, but that's for another day. They said the Law of Revision Council of the House of Representatives will write or implement the statute into the United States Code by dividing it up. So essentially, just think of it like putting it into bite-sized pieces so that you can cite the code, but you should be able to see that code and trace it all the way back to the authority from the Constitution, which for most of what they deal with us, they can't do that. They said they expand the code based on Congress. After the statute is in the code, then they task an agency. So just think of a federal agency, a federal law enforcement agency, for the title of that code. So we just was on it, wasn't we? Let's go back to the United States Code. Right. So they got aliens and nationality. So who's in charge of Title 8? They all over the news right now, right? You got ICE. All right. So then they create a thing. Well, technically, that's not true. Technically, the Department of Homeland Security would be over aliens and nationality, which technically they're not over nationality. They're only over foreign to the United States of America nationality. So they only deal with aliens. I know that this is not the topic I'm trying to talk about, but I just want you to get that picture in your head. They call it Homeland Security, but they don't have no jurisdiction in the States either. Another topic for another day. All right. So, right, they create all these agencies based on titles in the United States Code, right? So you got money and finance. So I think the Secret Service is over that. And then they got other agencies, the Security Exchange Commission. Okay, when they deal with the post office, they got a post office law enforcement agency, right? Because once they enact that statute, they have to set up an agency to execute that statute, right? And then what happens is that agency, I don't want to get ahead of myself. So they said the agency is responsible for that title of the code and are tasked with writing regulations to implement the statutes that they are to enforce. Okay. I know I'm talking over everybody's head. I'm sorry, but I'm working this out too. I got it. I just got to learn how to say it right. They said the agency responsible for that title is tasked with writing regulations to implement the statutes in the United States codes. That those regulations that these agencies publish are to be put into the Federal Register if they are to apply all over the Union. Are airports in the United States Code? Yeah, that would be under transportation, I'm sure. Yeah, transportation, telecommunications, commerce, all that. Navigation and navigable waters. So you have those regulations, if they are to be enforced, if they are to call it law enforcement, we're talking about federal things. All right. We're not talking about your states right now. If they are calling it federal, then it has to be published in the Federal Register. Say Federal Register. If it's not in the Federal Register, it is not enforceable. And I'm going to prove all this. I'm going to give you some codes tonight. They said those regulations are then published in the Federal Register as the regulations are created. So they said after they are published, they are a part of the Code of Federal Regulations. Now, I know this is a lot, and I'm going to keep going over it over the days. They said there are 3 types of regulations. You have legislative regulations, you have interpretive regulations, you have procedural regulations. Okay? I know it's a lot. I'm sorry. You have legislative, interpretive, procedural. See, if y'all type this in the comments as I say it, you get it. You just screenshot your comment and then be like, boom, okay, I got it. All right. So, what are legislative regulations? Legislative regulations have the force and effect of law authorized by the Constitution. Why? Because it's not presumed to take away any rights, and it is written by an actual department head. So, for instance, the Department of Treasury or the Secretary of the Department of Treasury would write a legislative regulation. And when I say that, I mean the attorney for the Secretary of the Treasury will write the legislation, will write the regulation, right? So that has the force and effect of law because it was created by a constitutional department, okay? And then you have interpretive regulations, which have the force and effect of law because they are also written by the secretary of whatever department. You should get the gist of where I'm going at. The secretary of a department of government, not just an agency, but the actual department listed in the Constitution. Then you have procedural regulations. So you have legislative, you have interpretive, you have procedural regulations. Procedural regulations do not have the force and effect of law. Why? Because they were not written based on the authority of the Constitution, and it is presumed to take away rights. And it's written, and how you know that is because it is written by an agency and not written by a department on which the agency has been delegated authority. Does that make sense? Does that sound a little legible? I got it. You got to get it. And this is on the live stream on YouTube. So if you need to rehear it, then you can rewatch it on YouTube if the audio works. I don't control the audio. All right. So 3 types of regulations: legislative, interpretive, procedural. Legislative and interpretive come from the head of a department. The procedural comes from just a little agency. And the agency is not even bound to follow procedural regulations unless them not following it would take away rights. Okay. But the agency doesn't even have to follow the procedural regulations that it creates. So again, the statute has to be enforced by an agency. So they create a statute, then they create regulations to enforce the statute. The statute is the bones, it is the structure. And then the regulation puts meat on the bones. You can't have one without the other. How do you know it's an actual body of law? Because if they have actual regulations that could be enforced across the entire union, it would be published in the Federal Register. If it's not in the Federal Register, the statutes or the enforcement regulations or the regulations that they're trying to enforce based on this statute, if it's not in there, you can't enforce it. All right. And then you got 3 types of regulations. The first 2 come from the Department of Government. And then the third is procedural, procedures, how they are to do things, how the specific agency is to do things, and they're not even obligated to follow that. So the only things, if they were lawful, would be in the Federal Register would be legislative and interpretive regulations. All right. How to tell what type of regulation? How do you know what type of regulation it is? They said they will have a paragraph in the transmittal stating the authority of the regulation inside of the Code of Federal Regulations, or at the bottom of the code in the Code of Federal Regulations. So for those who don't know, the Code of Federal Regulations, they have their own website. Just like the United States Code has their own website. The statutes at large, you can get to it by the United States Code because they'll have a statute right under it, and then you click it. And then what I did was I just clicked saved on my desktop. And then if I never need to look up a statute, which I don't, then I go there. All right. How do you tell what type of a regulation it is? They will tell you at the bottom of the Code of Federal Regulations. So it will tell you at the bottom of the regulation, right? So you got the statute and you got the regulation. If that regulation is enforceable across the union, then they will have a paragraph, or it will be in the Federal Register. The end. They said they will publish it in the Federal Register before it ever gets into the Code of Federal Regulations. In the Federal Register has a website. Be very clear. The Federal Register have a website. I'm not telling you nothing that you can't do on your own, right? So they said the purpose of the Federal Register is to give the public notice, public reasonable notice of the laws that will be enforced against them. And I'm going to show that to you. So they said publication in the Federal Register will happen before they even end up in the Code of Federal Regulations. And the purpose of the Federal Register is to give the public reasonable notice. Remember this, yesterday we talked about due process of law. Earlier today, we talked about due process of law. What is due process of law? Due process of law is notice and hearing before the judgment and the punishment. And it still has to be brought before the jury. which they conveniently don't do. So they said the purpose of the Federal Register is to give notice. That's the thing we have to have in order for it to be due process of law. In order for the constitutional interpretation of their powers be understood by reference to the common law. I read it every day. This is how it's implemented. That in order for it to square up with what they call due process, they have to give notice. Actually, I have this. This will help me. This will help me. Due process. This is the thing I couldn't read yesterday, but I guess I'm going to read it today. If you're on the Patreon, search requirement for notice. Requirement for notice. Here we go. All right. I can't read all of it, but you got to understand what I'm talking about here. Certain things from certain titles don't have any implementing regulations published in the Federal Register. Okay. Talking about you owe them something. It's not in there. Does everybody get what I'm talking about here? They said they have no implementing regulations published in the Federal Register authorizing enforcement. They said there are no implementing, or I said there are no implementing regulations published in the Federal Register authorizing enforcement actions within states of the Union against the general public. The Supreme Court said an elementary and fundamental requirement of due process. Where does due process come from? The Magna Carta. They said the basic fundamental requirement of due process in any court proceeding, which is to be accorded finality, is notice. They said notice to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. Say Federal Register. If it ain't in the Federal Register, they can't enforce it federally. If you don't get nothing else, just remember, if it ain't in the Federal Register, they can't enforce it, because the Federal Register is due process that they are going to enforce it across everywhere. They say it again. An elementary and fundamental requirement of common law due process, that phrase don't come from nowhere else but the common law of England, is notice. They said, this is another case. They say it is sufficient to say that there are certain immutable principles of justice which inhere in the very idea of free government, which no member of the Union may disregard, and as that no man shall be condemned in his person or property without due notice and an opportunity to be heard in his defense. They said it has never been doubted by this court or any other, so far as we know, that notice and hearing, say notice in the Federal Register, are preliminary steps essential to the passing of an enforceable judgment, and that they are, together with a legally competent tribunal having jurisdiction of the case, constitute basic elements of constitutional requirement of due process of law. They said notice and hearing before judgment and punishment. If it's not noticed in the Federal Register, it's not enforceable against the public. They said judgment without such citation. This is the same case. They said judgment without such citation and an an opportunity wants all the attributes of judicial determination. It is judicial usurpation and oppression and can never be upheld where justice is justly administered. They said if they didn't notice you or notify you of it, it's not constitutional. Who is this? They say it again. I don't know what this is from a law book. No, it's from another case. These are all federal Supreme Court cases because they're talking about federal things, right? We talked about states yesterday in due process. Okay, well, now we're talking about federal things. They said parties whose rights are to be affected are entitled to be heard, and in order that they may enjoy that right, they must first be notified. And then they cite 1 case, 2 case, 3 case, 4 case, 5 case. They said the constitutional right to be heard is a basic aspect of the duty of government to follow a fair process of decision making when it acts to deprive a person of his possessions. They said the prohibition against the deprivation of property without due process of law reflects the high value embedded in our constitutional and political history that we place on a person's rights to enjoy what is his, free from government interference. They say it again. The requirement of notice and an opportunity to be heard. Say a requirement for notice, a requirement of notice. The requirement of notice and the opportunity to be heard raises no impenetrable barrier to the taking of a person's possessions. They said fairness can rarely be obtained by secret. You can't say it's magical law, and then I ask you to show me where it's been notified that it's enforceable against the public, and you can't produce. They said fairness, that's not fair. They said fairness can rarely be obtained in secret. That a one-sided determination of facts, decisive of rights. They say again, the right to notice and a hearing is to serve its full purpose. An individual's possessions can be returned to him if they were unfairly or mistakenly taken in the first place. They said damages may even be awarded to him for the wrongful deprivation. They say this is no new principle of constitutional law. They said the opportunity for that hearing must be provided before the deprivation at issue takes effect. Before the deprivation at issue takes effect. That's what they said. They said it right. I said it right. They said the waiver of constitutional rights must be voluntary, but must be knowing with sufficient awareness. All right, let me see here. Notice. Federal Register. Federal. If it ain't in the Federal Register, you get that? Notice. I think I got something else on notice. I know what it is. If you're on Patreon, just type Federal Register. Federal Register. I think. Federal Regis. Oh, I need to read that. Okay, let me get that then. Federal Register. I guess it ain't federal legislation. Federal. Boom. Got it. The Federal Register. If you're on Patreon, just search the Federal Register. All right. This is some United States code for you. This is free. I know y'all like your United States codes. Here's some United States codes for you. Excuse me. Technically, this is a statute. This is not the code. All right. 60 stat 238. I'm going to put it in the comment section. Comment. Y'all see that comment? So when I say the United States Code is not federal law, it has to be coming from a statute for it to be federal law, right? All right. So they said, except to the extent that there is involved. I'm not going to read all that. Let me read what I want to read. No. I got to read it. Sorry. They said, except to the extent that there is involved any function of the United States requiring secrecy in the public interest or any matter related solely to the internal management of an agency, then they got this thing called rules. They said every agency shall separately state and currently publish in the Federal Register. Say Federal Register. I want you to say it 40 times. They said every agency shall separately state and currently publish in the Federal Register descriptions of its central and field organizations, including delegations by the agency of final authority and the established places at which and methods whereby the public may secure information or make submittals or requests. They set statements of general course and method by which its functions are channeled and determined, including the nature and requirements of all formal and informal procedure available, as well as the forms and instructions as to the scope and content of all papers, reports, and examinations, substantial rules adopted, as authorized by law in statements of general policy. They say all of this is called due process. You get to the end. I'm gonna read it. I'm sorry. It says substantial rules adopted as authorized by law in statements of general policy or interpretations formulated and adopted by the agency for the guidance of the public, but not rules addressed to and served upon named persons in accordance with law. So they say yada yada yada. No person shall in any manner be required to resort to organization or procedure that is not so published in the Federal Register. They say every agency has to do it. Every federal agency has to do it. And they said if they try to enforce anything that is not in the Federal Register, that no person shall be in any manner required to resort to organization or procedure that is not so published. The United States Code. Here's some United States Code for you. They said a notice of hearing or an opportunity to be heard by an act of Congress shall be deemed to have been given to all persons residing within the states of the Union and the District of Columbia when the notice is published in the Federal Register. Say Federal Register. They say, it came from Congress. Because remember, we went over the 3 types of regulations, right? They said they got legislative regulations, they got interpretive regulations, they got procedural regulations that are written by an agency. And how you know that what that agency wrote is enforceable across all the states of the union, or they say within the states of the union. I don't want to twist their words up. They said within states of the union and the District of Columbia when the notice is published in the Federal Register. So if it's not in the Federal Register, y'all, they say, it lawfully came from Congress. They said this would be, they could argue that this is constitutional because Congress would have been able to prove it by showing it in the Federal Register. They said, bet. If it's not in there, we read it earlier, what they say? No person shall be in any manner required to resort to organization or procedure that's not published in the Federal Register. Here we go. Here's another code for you. I know you like your codes. That says 5 USC 552 that each federal agency shall make available to the public information as follows. They said each agency shall separately publish in the Federal Register for the guidance of the public. They said each agency. They said everybody got their own things that they post in the Federal Register. They said a person may not be in any manner required to resort to, or be adversely affected by a matter required to be published in the Federal Register, and it's not in there. Does that make sense, y'all? I'm not crazy. I'm not a lunatic. They said if it's not in there, no face, no case. So when I ask you to say Federal Register, they say each agency got to do it. They actually say that, I don't know. They got another thing. I don't know if I have it on here. I just need to stay in order. Let me just stay in line. But essentially what I was going to say is they say that one agency can't try to use the Federal Register publication of another agency. So they'll say, oh, well, we're all one federal government. And no. If you're on the Patreon, you can search special agent and they'll teach you that, I think this is the Supreme Court of New York. They teach that an agency or a special agency of which a special agent would be from only has one specific responsibility. And they're not allowed to be enforcing things outside of the district that another agency has been given specific authority over. So they say when it comes to this Federal Register thing, okay, well, one agency can't say, well, because the other agency did it, that means that we can enforce it too. They say, no, if you didn't publish it, then it's not enforceable. All right. So they say, I'm gonna read it again. Each agency shall make available to the public information as follows. Each agency shall separately publish in the Federal Register for the guidance of the public. Why? Because if they're going to enforce it across the public, then they got to be able to show that it's enforceable across the union. The way they do that is they put it in the Federal Register before they even make code out of it. Before they make a federal regulation out of it, they put it in the register. So before we were born, that thing should have already been there. When did the Federal Reserve get set up? 1913. Okay, well, it should have been in there. And it ain't been in there, boys. It ain't been in there. All right. So they said, each agency shall separately publish in the Federal Register for the guidance of the public. They said a person may not in any manner, how much manner? None of it, be required to resort to or be adversely affected by a matter required to be published in the Federal Register, and it's not there. Now, context, watch this. They said, so there's not always your favorite thing to hear, right? They said regulations, because this is where they got sexy attorneys. They ready for this stuff. They say regulations. This is the next code. So that was 5 USC 552. Okay, we'll go to 5 USC 553. And they say, all right, now we ready to argue. So you better be on your stuff. They got an attorney ready to go, boy. They keep him in the dungeon. He read this stuff all day. Right? They said, all right, now regulations don't need to be published in the Federal Register if they will only affect federal employees. So they gonna argue, oh, well, we don't have to actually have it published in there. Well, no, you don't have to have it published in there and enforce it against federal employees. And guess what? They don't have no evidence that you're a federal employee. They don't have none. Well, what about a birth certificate? No, that's not admissible in court. But what about the social security number? Not admissible in court. Sorry. They never present those things. If it's not in the Federal Register and you're not a government employee, it's unenforceable. They say this section applies according to the provisions, except to the extent that there is involved a military or foreign affairs function of the United States or a matter related to agency management, personnel, or public property, loans, grants, benefits. Make sure you don't have no benefits or contracts. Okay. Now, outside of the benefits part, none of those are valid. I don't have no contract. A void contract from its inception has never been valid. So, all right, here we go again. Here's that regulation. See, we told you the statute, then we showed you the code, then we're going to show you the regulation. But I can't show you the Federal Register because they don't have it published in the Federal Register. Oh, this is fun. This is fun. This is fun. This is fun. They're going to cut my head off one day. All right. They said, again, they're just reiterating. They just put the code in the regulation now. They said the effect of failure to publish federal regulations in the Federal Register is as follows. They said the effect of failure to publish, such person is not required in any manner to resort to or be adversely affected by such matter if it is not so published. And they said such matter which imposes an obligation and which is not so published or incorporated by reference shall not adversely change or affect the person's rights. Dun, 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 dun. Does that make a little sense? Just a little bit. If it's not in the Federal Register, y'all, that's all I got. If it's not in the Federal Register, that's the only question you got. You don't answer questions. I just want to see it in the Federal Register. They gonna show you somebody else's agency. No. You said you were X, Y, and Z. I want to see X, Y, and Z's publication in the Federal Register. No, you can't use theirs. They weren't here. They ain't not here. You said you was from. Blame it on the apple juice, everybody. Blame it on the apple juice. I think I read this case earlier, but I'll read it again. United States Supreme Court said there. Well, I don't know if they said that. Okay, I put a little explanation before. Yeah, they didn't say that. They said there are certain immutable principles of justice which in here in the very idea of free government which no member of the union may disregard. They said as that no man shall be condemned of his property or person without due notice. Let me go to due process because they say that. They say that it comes exactly from the Magna Carta, y'all. That's why they don't talk about this common law stuff. I promise you that's why they don't talk about it. They said, no, we don't do that common law stuff no more. Why? Because them jokers lying. I said, no, we don't do that common law. That's in old Britain. Yeah, I bet. Why? Because Magna Carta due process requires notice and hearing and then presentment before the jury before you get to give judgment and punishment. Due process. Let's talk about due process. Due process. Due process. Due process, a cuss word, boy. You get this due process down, you'll be nasty. Nasty. All right. Let me see. Somebody said notice. Let me see. New Hampshire. Look at this. The Supreme Court of New Hampshire said that certainly they're criticizing, well, actually, they're citing a Rhode Island Supreme Court case. So they said in this old case, it was held that such a provision in the Constitution of Rhode Island meant law of the land, due process of law, uh, is included in the right to contest the change. The judge said certainly this does not mean any act which the assembly may choose to pass. They said law of the land within the meaning of the term. They're mentioning Michigan. New Hampshire said law of the land within the meaning of the term as used in the Constitution of Michigan is a law which hears before it condemns, which proceeds upon inquiry and then renders judgment after trial. There's one that says notice. I'm trying to find the one which says no. I'm trying to find a state one that says notice. They say guarantee. That's Indiana. Yada yada yada. All this is on the Patreon, by the way. If you're not on the Patreon, everything I read to you tonight is on the Patreon. If it's a book explaining the topic, you can download it. You can read, screenshot everything. I think it's Minnesota that does it the best. Let me see. Yeah, let's go to Minnesota. I like Minnesota. I ain't never been to Minnesota. I'm probably never going to Minnesota. But Minnesota, they got us on this one. They got it. They carried the ball on this one. Minnesota, Minnesota. All right. Due process. No, that ain't it. There you go. Due process versus the legislator. All right, so I read this all the time. They said, what is due process of law? It says due process renders judgment only after the trial. They said in judicial proceedings, due process requires notice, hearing, and then judgment. There you go. You got to have that notice. If they don't notify the public, because this is the federal corporation and they do everything that pertains to the public. Okay, well, how do you know they did it lawfully based on the Constitution? It's got to be in that federal register. Minnesota said, "Oh yeah, this comes from the Magna Carta." They say, "Yeah, you got to give notice before you presuppose to be enforcing things that can take away people's rights." So if it relates to something federal that presupposes to take your hard-earned labor, and they don't have notice of it from a specific agency published in the Federal Register, no face, no case. Supreme Court of Minnesota said common law due process renders judgment only after the trial. They said in a judicial proceeding, in order for this judicial proceeding to be called lawful and constitutional in Minnesota, you have to have notice of the thing that they are trying to enforce against you prior to you getting in court over the issue. They said, who told you you could enforce this? Remember, I told y'all Article 1, Section 8, exclusive legislation in all cases whatsoever over such district. So they got to be able to show how they went from the District of Columbia to Arkansas. The way they show that, it's a lot. That's just a little bit. There's a mountain of evidence against this stuff. One, we already talked about, it has to be published in the Federal Register that you have permission to be enforcing this stuff. The next thing is it has to be, what if they're going to levy something or they're going to presuppose to take it, it has to be signed by a judge. And then another thing is they have to have permission from the sheriff that they're even in the neighborhood of somewhere in a state. They said all of this is common law due process. You have to have all these ducks in a row. They're supposed to go stop by the sheriff's office and get permission before they go in order for it to be considered lawful. Then they said if they're going to levy or create a warrant, it has to be signed from a judge, not on a piece of computer, not a tablet. It has to be a piece of paper signed from a judge in that county. Because remember, they're all a corporation, so they got to do all their fake paperwork stuff. Okay, well, the magistrate is what they call a Roman praetor over that commercial district. And if that enforcement did not get permission from them and didn't get permission from the chief executive officer of the county called the sheriff, why don't these people on the internet explain this stuff? Are y'all tired of all these scammers? They don't explain nothing, y'all. And then these guys have to have permission or have to have enforcement regulations published in the Federal Register. They don't show ever how they got from the District of Columbia to Oklahoma or Mississippi or Tennessee. They just show up and start kidnapping people and taking their stuff. Now, I don't know the issue with that ICE thing, but I bet you $1,000 they can't show how they went from the District of Columbia to Minnesota. This is Minnesota. And didn't that issue happen in Minnesota with that lady getting taken out? I bet you $1,000 they can't show how they went from the District of Columbia to Minnesota. Common law due process. This is the stuff they get away with because of our ignorance. Our parents and grandparents dropped the ball. And the ones before the grandparents. Does this make a little sense? Federal Register. It requires notice in order for it to be lawful. In order for it to be considered American law, they have to publish it, or in order for it to be considered federal law that can be enforced against within the states of the union, it has to be published in the Federal Register. And almost nothing from the Internal Revenue Service is published in the Federal Register. It's not even, Title 26 is not even positive law. All right, well, what else? I'm done. Any questions? See, this the stuff an attorney can't explain away, y'all. This what I'm telling y'all. There's that you can't explain this. Right? You're trying to enforce something that the law does not authorize. I'm talking about you'll hear crickets in that courtroom. You talk about this stuff. Well, who told you you could do it? Who told you you could create a case? Who told you you could create information on this? Because even the agent didn't have permission based on the Federal Register. So all of you are engaged in fraud. All this stuff is nasty. That's why they don't show my stuff to about 4 people. They said, no, we're not mute censor. Hit the censor button on his account. Yeah, we're not showing this to nobody. Because I figured it out. I figured it out, boys. It took a lot of reading. I didn't talk about this for a long time. I said, no, let me keep my mouth shut. I got it now. I got it. I figured it out. That Federal Register is nasty. How can we apply this to the state? Well, the state is different. You don't get attached to the state if you don't have a state ID. You don't get attached to the federal if you don't have a state ID, but that's another thing too. But primarily for state issues, if you don't have a state ID and you don't have a car, now people have property issues, and that's a whole nother thing, right? Property issues, again, that if you don't have a land patent or you're not on some land that's virtually never been claimed before. See, most people live in the city. So when it comes to property rights, that's a whole nother argument because they've had hundreds of years to overlay presumptions over that house or that land. So that's a lot harder. But this is why it's important for you to read and study your state constitutions because many of your state constitutions explicitly state that you get a trial by jury in a civil case. And that's what this whole due process thing is about. They say you're not supposed to be having your life, your liberty, or your property taken away from you unless the jury did it. So they get away with it and they get to presume a lot of things because we attach to those statutes by way of a legal fiction, which is primarily a state ID or registered property or a card that they have information on. So it's easy for me to say, oh, well, all you got to do. But when it depends on the issue that you're dealing with, that this becomes a lot harder because they've already created presumptions that you are attached to the jurisdiction by way of a state ID and a car that you drive. So we got to come together. We got to move to the same county. We move to the same county. Be nasty, y'all. We get in so much trouble. It'll be so fun. Any questions? Any questions? All right. Well, I'm getting up off of here.